Hey everybody, I'm Natasha Kirchuk, and thanks for joining us for ILTV's weekly program One-on-One with Alan Dershowitz. We want to give you, our viewers, a chance to have your questions answered by Professor Dershowitz, one of America's greatest legal minds. He's a leading expert on criminal and constitutional law, civil liberties, and the Arab-Israeli conflict. Just like last week, today we have a special treat for you. We're going to present you highlights from Professor Dershowitz's visit to Israel this month. He had many exciting moments meeting with the president, prime minister, and other leaders, and made several public appearances. By far, he was most at home when he spoke to 500 law students at Tel Aviv University in a unique conversation with Israel's chief public defender, Dr. Yoav Sapir, who was introduced as the Alan Dershowitz of Israel.
Professor Dershowitz, it's really a pleasure and an honor that you're here with us.
Well, thank you for inviting me. This is one of my favorite places in the world, in front of students and in front of students at Tel Aviv University. I was lucky enough a few years ago to get an honorary doctorate from Tel Aviv University, at which time the hard left called me a McCarthyite. So have been called a Dybbuk from the right, a McCarthyite from the left. I'm comfortably a centrist liberal, and we'll talk about some of those issues. But thank you so much for inviting me. I look forward to our conversation.
So we're going to spend most of the time speaking about criminal justice issues and in particular defense issues. But since you're going to have a new person in the White House I believe, next month,
yes.
With your permission, I will ask you a couple of questions regarding the recent elections, the recent presidential election.
Sure.
So, according to recent reports, Hillary Clinton received more than 2.5 million more votes than Donald Trump. So my question to you is, first, could you explain a little bit the system?
Sure. So the Electoral College was supposed to balance the power of large states by giving power to smaller states. It was part of a compromise. It was also part of the slavery compromise because it made it clear that southern states would have enough electoral influence to make sure that the Northeast didn't always dominate in elections. And it's an anachronism, but to say that Hillary Clinton should be president under our system is like saying that a football team that had the most shots on goal should win, even though the other team managed to score one goal in a disputed call. You have the rules, and under the rules, Donald Trump won the election, but it's a reality. And within an hour after he won the election, I called his assistants and I said, I offer my help 24/7 if you want any assistance on Israel, any advice on Israel, as I've done to every elected president of the United States and every prime minister of Israel.
The last time that the winner of the popular vote lost the elections was in 2000.
And I was the lawyer. I was one of the lawyers for Al Gore in...
Right. The Supreme Court actually played a very important role there when, for the audience who are not well familiar with the facts, I believe that the Supreme Court reversed the decision of the Florida Supreme Court that ordered a recount.
That's right.
And you were involved in that litigation, and subsequently you wrote a harsh critique of the court using words that are rarely used to criticize the court, such as corruption, I believe, and calling the majority judges liars.
No, hypocrites, really.
Hypocrites?
Yeah, right.
So what was it that so upset you?
Well, what upset me is that first of all, the vote went along party lines. 5 Republicans voted to stop the recount, 4 Democrats voted to let it go forward. It hurt the Supreme Court's integrity very deeply. In my book, Supreme Injustice, I went through all of the 9 justices and showed how their opinions were completely inconsistent historically with how they voted in that case. And tragically, in that case, every justice of the Supreme Court got to vote for president twice. They get to vote for him when they went to the polls, and they got to vote for him when they voted in the Supreme Court decision. Justice Harlan, who was one of the great conservative justices in American history, the day he got appointed to the Supreme Court, he said he will never again vote in a presidential or any election because he wanted to be completely out of politics. Those days are gone forever. The Supreme Court is highly political, which is why both candidates in this election ran on what kind of a Supreme Court they would appoint if they were to be elected president.
So this brings to question the method of electing or appointing judges, which is also very relevant here. So in the United States, it's a very political method. The president appoints that judges, and it has to be confirmed by the Senate.
Right.
In Israel, there are very strong political voices now to make the system more political than it is. The claim is that if the court deals with political issues, then it should reflect better the political map. What do you think about it?
You know, I follow Danny Friedman's writings, and I follow the dispute very closely in Israel. And it seems to me that the Supreme Court ought to be a check and balance on the elected branches of government and not represent the elected branches of government. They should not be popularly elected. I like the traditional method in Israel of selecting judges and justices, of having a committee which has a majority of professionals, that is either Bar Association members or judges, and only a minority of politicians, and I'd like to see it kept that way. But I understand, because as a Supreme Court becomes more political, as it gets involved in issues that affect the daily lives of people, it's inevitable that people will want to have much more of an impact on having the judges selected. When you have countries where the Supreme Court, or like the American Supreme Court for the first century of its existence, or the British Supreme Court, they decide nothing of importance. I mean, for example, the Bill of Rights in America were never part of constitutional adjudication for the first 100 years of our history. So nobody cared who was on the Supreme Court. It didn't affect the lives of individuals. But in America, the Supreme Court decides whether your children can pray in the school, whether your daughter can have an abortion, whether your son can marry his boyfriend, whether health care is constitutional. All of these things matter, so you can easily understand. So when the Supreme Court, with my friends, Aaron Barak, who's next door, you should all be listening to him. I don't know why you're here listening to me. If I had a choice, I'd be over there listening to him. But thank you for being here. I appreciate it. When my friend Aaron Barak and others of my friends on the Supreme Court, Dorit Banish and others, moved the Supreme Court toward more activism, they inevitably created a situation that they should have realized, that the public would want to become more involved in deciding the judges that would decide matters that affect their daily lives. So this was not an unanticipated result. It should have been a fully anticipated result. Will you all please say hello to my wife who just walked in? And so, thank you for coming. If she knew that Aaron Barak was speaking next door, she'd be there too. But so it's not surprising to me that there is a movement. The same movement is occurring in England. As the British Supreme Court this week is hearing argument on the constitutionality of Brexit. And inevitably, you're going to see a movement toward people wanting to have more of an impact, particularly in Britain, where the Brexit vote was an anti-elitist vote, and there's nothing more elitist than judges. So you're going to see a distancing between the professionalism of the court. Also, with the need to have greater diversity. You know, in the British courts, people wore wigs. Why did they wear wigs? Because they all were supposed to look the same, because the law didn't reflect individual personalities. It was a manifestation of some abstract legal principles in the sky that any smart person could equally discern. If you now want to have more diverse courts, you want to have more women on the courts, which is very, very important. If you want to have more Arabs and Muslims on the court here in Israel, more people of color, inevitably it becomes a more politicized process. So it's a knife that cuts both ways. There are no free lunches. Everything has a cost. And the cost of having a more activist judiciary is you're going to have a more activist populace wanting to constrain the judiciary.
After discussing the U.S. elections and electoral system, Alan and Dr. Zapir got into a wide-ranging discussion of issues that affect the U.S. and Israeli criminal justice systems. The title of the discussion was The Best Defense and touched on issues like racial discrimination, comparing the U.S. jury system with the Israeli system of justice, and Professor Dershowitz's most personal reflections from over 50 years of criminal law.
Race is a major factor in every aspect of the criminal justice system. Whether you're going to be stopped whether you're going to be arrested, whether you're going to be indicted, whether you're going to be convicted, whether you're going to win your appeal, whether you're going to be executed, whether you're going to be paroled early, whether you're going to be recalled if you're on parole and put back in the system. If you do statistical analysis, you find two factors determine these. Both are racial. One is the race of the defendant, and the other is the race of the victim. And that is, white defendants are given far lower sentences when they attack black victims than when they attack white victims. Very few people are on death row today in America for killing black people. You're on death row today if you kill a white person. And that's so distorting in our criminal justice system, which is why my friend Steve Breyer, Justice of the Supreme Court, has been spending so much time trying to raise consciousness about the unconstitutionality of the death penalty as applied in the United States today. You know, as the Torah doesn't say that you'll get justice. It doesn't even say justice you should seek. It says tzedek tzedek tirdof, which means it's not going to be there. You have to chase after it. You're never going to catch it. It's an illusory concept. It's always a chase. The struggle for justice never, ever stays won. The pendulum swings widely. Sometimes it swings in direction of justice, sometimes against it. I do not agree with Martin Luther King that the arc of justice always moves toward justice. Anybody who lived through the Shoah, anybody who's lived and watching Aleppo as we speak today, cannot be as confident that the arc of justice always swings more to justice. First of all, we have to make it swing to justice. That's our job. We don't just let it swing. We have to influence it and affect it.
You mentioned the issue of race, and of course this was race played a major role in one of your most famous trials, the O.J. Simpson trial. Could you say a little bit more about the role of race in the criminal justice system?
Sure. In the O.J. Simpson case, the major piece of evidence against him was a sock that was found on the floor in front of his bed just hours after the double murder. And the sock miraculously had on it O.J. Simpson's blood and the blood of both of his victims. What could be a better piece of evidence? Well, it was a fantastic piece of evidence, except for three problems. Number one, there was a video taken before the police came and claimed to have found the sock, and it showed there was no black sock on the white rug. Number two, the blood on the sock, and only the blood on the sock, had a chemical called ETNA, which is an anticoagulant not found in the human body, but poured into test tubes to prevent the test tubes from coagulating, which demonstrated that the police, and we know the name of the policeman, Officer Van Adder, had taken the test tubes home with him and poured them on the sock as it was lying flat. And ultimately, how did we prove that? I hope you can see as I sit here. If you splatter blood on a sock as somebody's running through a killing field, here, let me stand up. If you could hold the mic, I can show it. It's okay. That's all right. If you spill the blood on the sock, you will find that the outside of the sock and the second inside have the same mirror images. But you will not find a mirror image on the third side or the fourth side because the leg intervened and the wearer of the sock wore it sufficient time for the transfer, if it occurred, to be a crystallized transfer, not a mirror image transfer. And any blood splatter expert would understand that, and we saw that on the sock. The sock had 4 mirror image blood samples on all 4 sides. And so we were able to prove conclusively that the police tried to frame O.J. Simpson. In their mind, they were framing a guilty man. For sure, they knew he did it, and as far as they were concerned. And they also believed that the glove, which was found, which also had blood of both the one victim and O.J. Simpson, would be suppressed from evidence under our Fourth Amendment because it was found without probable cause and without a search warrant. So in order to create a new piece of evidence that would replicate the real evidence against him, they created this this evidence of the sock. The jury understood our demonstration, and every single one of the jurors came to the conclusion that sock was a fake piece of evidence. So justice is always a process. And I think the jury system is better for America, and I think the non-jury system is better for Israel. I think every legal tactic or every legal weapon or development has to be looked at integrally through the culture of the country, the history of the country. America is an extraordinarily diverse country, and the idea of a single judge administering justice just isn't consistent with the American style. But it comes at a heavy cost. We get many cases where the judges would do a better job evaluating the facts. But let me give you another example to show you how difficult. In the Olmert case, you may remember the following situation occurred. The prosecution knew full well that one of their major witnesses was dying, and they knew that he might not live long enough to be cross-examined. And they put him on the witness stand. They kept him on direct for a long, long period of time. And then before Olmert had a chance to cross-examine him, he died. So the judge heard uncross-examined, very, very incriminating testimony against Ehud Olmert. And I helped the lawyer prepare that part of the appeal. And the judge, however, said, "Oh, don't worry about me. I'm a judge. I'm not a jury." I totally discounted what I heard from the witness. I didn't take it into account in making my decision. Right. That really understands human nature. If you think that any judge is capable of unringing the bell or taking the smell of the skunk out of the jury room once the skunk has been thrown into the jury room, I got a bridge in Brooklyn to sell you. So I really do think that the system here relies a little too much on judges being infallible and able to evaluate what they will take into account and what they don't take into account. Look, justice is imperfect, and one has to pick a system that best suits the characteristics of a country. And I think you have picked a system that works for your country, and we've picked a system that works for us.
There's one question I'd like to ask you, and I know you'll have to excuse me, you've been asked that question probably
Sure.
1,000 times.
Yeah.
How do you justify to yourself protecting, representing individuals accused, sometimes guilty, of the most heinous of crimes?
Right. First case I ever had as a young lawyer, I represented a Jewish terrorist, a young man from the Jewish Defense League. In those days, the Jewish Defense League was protesting the Soviet repression of Jews, and so this young man made a bomb, a smoke bomb, that was planted by the Jewish Defense League in the offices of Saul Yurok. It went off. It was not supposed to kill anybody. It ended up killing a young Jewish woman, and I knew my client was guilty. The evidence was overwhelming, every conceivable piece of evidence, and he told me. And he said publicly in court, and we won the case because they had obtained his confession and his cooperation through unlawful means, and it was an awful feeling to have my client walk out of court knowing that he had the blood, even though he didn't intend to kill. Nonetheless, it was his act that caused the death of a terrific young woman, and it's awful. It's even worse, however, and I've had this case where I've had two young boys on death row who I knew for absolute certain were innocent, and I lost initially in the Supreme Court in a 5-4 decision. And believe me, I lost more sleep over losing a case in the Supreme Court for two innocent boys who cried on the phone to me every night. They didn't want to die. I had nightmares. They were going to be subject to the gas chamber. And I had nightmares of them screaming as they were going into the gas chamber for me, and could I get them out of the gas chamber? Ultimately, we won the case, thank God, and we were able to get them the death penalty eliminated. But you know, when you're a criminal defense lawyer, you lose sleep both ways. When you defend the guilty, or when you lose on behalf of an innocent person. But remember that when a guilty person is acquitted, that's part of our legal system. Better 10 guilty go free than 1 innocent be wrongly confined. It all comes, of course, from the story of Abraham and Sodom. Chalila lacha hashofet kol haaretz lo yaseh mishpat. How dare you, God, the judge of all the world, will not do justice? What if there are 10 innocent people among the guilty? Abraham stops at 10, of course, which is where the concept of better 10 than 1 comes from historically. So the acquittal of the guilty is part of our system. The conviction of the innocent is not. Anytime an innocent person is convicted, the system has absolutely failed. My final parting words to you, because I think we're coming to an end, is that law is very complicated, very nuanced. There are no simple answers. Almost every right has a cost attached to it. Every good rule, every good change has some negative consequences. And if you want to be a criminal defense lawyer, you have to learn to live with moral ambiguity. You have to learn to live with uncertainty. You have to learn to live with some of the questions we've raised here today. But I have to tell you, there's no more exciting job in the world than being the only person standing between you, between your client, and between imprisonment, or in where I practice law, death. And so if you want a challenging, incredibly difficult, interesting career, being a criminal defense lawyer is certainly high on the list of things you should consider doing.
That's all the time we have for today. Next week, we'll continue with more from Alan's visit to Israel before returning to our regular format with questions from you, our viewers. If you'd like Professor Dershowitz to answer your questions, go to ILTV.tv or our Facebook page and submit them. We'll see you again next week.